Commissioner O'Donnell. Commissioner O'Donnell, are you here?
All right, so this is case 9702, the application by the Potomac Electric Power Company for an adjustment to its retail rates for distribution of electric energy. And we'll start with taking appearances.
Good morning, Chairman, Commissioners. Kim Curry, representing Pepco.
Good morning, Your Honor. I'm Fran Francis, representing the Apartment and Office Building Association. I brought with me today Bruce Oliver, who is our consultant. In this case, he's seated right behind me to help answer questions. Thank you.
Good morning, Your Honor. Jacob Auslander on behalf of the Maryland Office of People's Counsel.
Good morning, Mr. Chair, Commissioners. Lloyd Spivak for the Commission staff. I also have with me David Hoppock of the Commission staff, and he will be answering questions regarding technical issues, if you have any, specifically with regard to the tariffs and how the rates are expected to be implemented and the BSA sorts of issues at some point.
Good morning, Your Honor. Steve Tolson, Assistant Attorney General. I'm here for the Maryland Energy Administration, which is a signatory to the motion now before the Commission.
Good morning, Mr. Chairman and Commissioners. James McGee with the Law Office of Robert Castro on behalf of Prince George's County, Maryland.
Anyone else? Okay, so I guess we'll turn to Pepco.
So it might be useful just to give a little bit of a history of what brought us here. So on June 7th, we had a pre-hearing conference in this matter to, among other things, confirm a procedural schedule for this case. A few days before that pre-hearing conference, staff filed a letter asking for the litigation in the case to be delayed, citing resource constraints and concerns. Pepco filed a responsive letter asserting various legal rights to have the case heard within a statutory time period of 10 months. The Commission directed us to convene as a group and see if we can work out any differences and see if we could come to a resolution, and that's precisely what we did. And that culminated in the settlement that we filed on July 21st. So what that settlement does essentially is give staff an additional 90 days. It suspends the procedural schedule for that period. And I could give a quick summary of what the settlement covers, if that's helpful.
Sure.
All right. I look at really as kind of four components. The first step is we leverage Section 4204B of the Public Utilities Code and have our rates go into effect on April the 1st. The second step, which is simultaneous with the first step, is that we give customers an offsetting credit of those rates going into effect. And so the net total of the interaction of those two steps is that customers will not see an increase in rates. The rates remain the same. The third step is there's a procedural schedule that we provided with the settlement that the signatories agreed to that presumes a commission order on June 10th. After that order is issued, the fourth step, that's the third step. The fourth step is we would, in July, about a month after the order is issued, file for a true-up to recover those costs or recover those revenues that we did not collect during that 3-month deferral period. So if I could use like maybe numbers as an example to help illustrate it a little bit more. So let's say, for example, the rate that goes into effect on April the 1st is $1. That's the incremental rate increase that goes into effect. We would give customers a credit of that $1, and then we would file a true-up. Let's say the commission in their June 10th order approved a rate of 80 cents instead of the dollar. Then in the true-up process, we would file something with the commission to recover that 80 cents that we were unable to collect during that deferral period. So that's how it will work kind of in practice. It was a product of some good collaboration with all the parties. We had 9 of the 10 parties sign on to this. We appreciate the support of all the parties in coming to this point. We had one virtual meeting. We exchanged edits via email. So it was a very good collaborative process whereby we worked together. I'm going to pause there, and if you have any more specific questions about the details of the tariff, I do have Kasia Dana here with me that could assist with those answers.
So let me turn to the commissioners, see if we have any questions for Pepco. Commissioner O'Donnell, any questions? All right, so actually I got one. So what are customers going to see on their bills if this process goes forward?
They will see no change. The steps that I described to you will happen behind the scenes, so they will see no change in their existing rates.
Okay, all right.
If I might make just a brief statement. As Counsel for Pepco noted, this came about because staff did have some very serious resource constraints with the number of rate cases that are before the Commission. I would like to add my thanks to both the company and all the other parties for their efforts in bringing this about. This agreement does give us everything we needed, including the fact that although the company's rates as filed go into effect on their books, it is not something that customers will actually see, and the only rate changes the customers will see will happen after the Commission issues its final order in this proceeding, and will be at the rates that the Commission sets in that order. And that was very important for us. So it was those two things, and it does give us the extra time that we needed and the time offsets from all of the other cases we're dealing with at the moment. So it was very helpful in that regard.
So any other entities who signed on to the agreement want to make any comments about it? Mr.
Your Honor, OPC does support the agreement as filed. There has been discussions about how the information will ultimately be conveyed to customers, because there will be a period during which the rates will not only include the rate increase that's approved, but also a collection of the deferred revenue that was not collected for the first 3 months of the rate effective period. And I don't believe that the agreement sets that out, and certainly not in the detail that ultimately will need to be set out in order to satisfy OPC.
So essentially it goes on the to-do list.
That's correct, Your
In
Honor.
the case, okay, fine. Representative from Prince George's County, and the other folks who signed on to this, if you don't have anything you want to say about it, that's fine too, but I just want to give the opportunity to the folks from Prince George's County.
No comments, sir.
Mr. Tolson?
No comments, Your Honor.
Okay. So one entity did have some concerns about it, so let me turn to Ms. Francis.
Thank you, Your Honor. To start off with, I want to say AOBA was and we still are supportive of, number one, the 90-day extension. We are also supportive of the schedule that's adopted with the stipulation, and we are also supportive of a reasonable revenue deferral mechanism. However, I can say from the outset that we don't relish the position that we're in, being the only party not to sign the settlement agreement. I wish I didn't need to be in that position, and the reason we are is because I believe it is in the best interest of my members, which are small, medium, and large commercial customers, as well as all customers. We believe that this, paragraph 6 of the stipulation needs to be clarified, and we believe that the RDM tariff, one provision of it, is not clear and needs to be clarified. And to start off with, I would like to point out to the Commission that, for example, paragraph 4 of the stipulation is very specific. It even states, for the avoidance of doubt, the settling parties clarify that. And then it goes into more specifics on the dates that things are going to happen and on the specific amount of revenue requirement that is going to be implemented at one time. The document was very carefully worded and gone over so it would be clear and specific. However, focusing on the RDM tariff for a moment, we believe it's less clear, and while the customers are not going to be seeing an increase as stated by counsel for Pepco as well as the staff, what they will see is the revenue deferral mechanism rider. They will see rider RDM. And that's what we believe needs to be clarified. For example, as we state in our comments, the RDM tariff language, the reference at the end of that paragraph to revenue per customer targets in effect for the period April 1st, 2023 through March 31st, 2024 should be replaced in order to be clear that it's revenue per customer targets in effect for the period April 1st, 2023 through June 30th, 2023. What is confusing is the paragraph as written talks about the 3 month period being adjusted for a 12-month, based on 12 months worth of data. That doesn't make sense. What it needs to be is for the 3-month period, April 1st, 2023 through June 30th, 2023. Does that mean you're going to adjust 3 months worth of data based on 12 months worth of data? Or are you only comparing 3 months worth of data to another 3 months period of data? We believe that it's the latter. We believe that was the intent of that clause, and we believe it needs to be clarified. That's our first problem. Second, near the beginning of the last sentence of paragraph 6, I know I'm jumping back and forth. It states, the authorized distribution revenue calculated for the period April 1st through April 1st, 2024, June 30th, 2024. That reference, it does need to be clarified because you cannot tell from the way it's written whether it's referring to overall distribution revenue, whether it's referring to distribution revenue for each rate class, or revenue per customer amounts for each rate class. We believe it is really referring to authorized revenue per customer amounts calculated for each rate class. So we believe that this stipulation, this paragraph, is unclear because you can't tell whether these amounts will be based on a total system basis, a class basis, or a revenue per customer basis. Third, our next comment was that in the middle of paragraph 6 of the stipulation, as well as the first line of paragraph 5, there's a reference to, quote, the regulatory asset. There are other regulatory assets in this case. For example, in the application alone, they refer to a regulatory asset for COVID-19. They refer to a regulatory asset for EV. I don't think we should just have a general designation. There's going to be some regulatory asset out there. Just call it something. Give it a name. The 9702 deferral regulatory asset, any name so it is specific and doesn't get lumped in with any of the other regulatory assets which will be considered in this case. And fourth, the language in paragraph 6 indicates that Pepco shall recover from the customers the deferred credit amount via a surcharge over the period August 17th, 2024 through March 31st, 2025. We believe that starting in the middle of the month greatly complicates the calculation. Now, while Pepco obviously can do math, as well as can the parties sitting here at this table, customers not so much. And they need to be clear as to how this is done. But one other important point, that presumes that customer usage is spread uniform throughout the month. I know specifically from my members, our largest members are all billed in the last 2 or 3 days of the month. So once you start dividing the month in a half, it's not a question of prorating mathematically. It's a question of the usage throughout the month is not uniform. That's the problem. It was very simple to either make the date September 1st. There's no reason that AOBA can determine that it's August 17th. It's another 2 weeks. It would make the computation cleaner. The BSA is a clause that obviously is important to my members. My members pay it. It is something that AOBA has been watching since its adoption. That is an issue for us in every rate case, probably will continue to be in this case. And any clause that specifically references the BSA must be as clear as possible. And I don't want to divulge any conversations that were had or emails going back and forth, but I can say at no time did Pepco indicate to AOBA that our suggestions were incorrect. What they indicated was there's a timing problem of getting this done and getting the document signed, that there was an urgency to it. I don't discount that there was an urgency to it, but I think it would have been more appropriate to make the clarification changes up front, taking another day or two, recirculating a draft, since these are not changes that would distort what other parties signed onto, and having a clean document that, most importantly, customers would understand. Thank you, Your Honor, and I do appreciate this opportunity to address the issues that are important to us.
So, any question for Ms. Francis?
I think Pepco wanted to respond.
Well, actually, let me deal with any specific questions on what she's asked, like clarifying questions and things like that, before I have Pepco respond.
No,
So,
I think-
Commissioner O'Donnell, you have any?
Actually, I do. Have these specifics, because they're very, very specific, were they tried to be resolved by the parties, and if they were or were not, why? Why, why couldn't we resolve them, or what am I not seeing here?
I would like to address that. AOBA submitted several edits to the document, some of which were included. We also submitted, very similar to the document that we filed with this commission, very similar to the 4 outlines I just outlined. We submitted basically those same 4 points to Pepco, and on all of our emails, we did copy staff. We did not copy all of the other parties because we felt it would just add confusion. At that time, there were so many emails going back and forth, and we felt that if Pepco had approved it, and staff had no objection to it, that it would be best rather than adding confusion. And I was informed that time was important, that this needed to get filed. And like I said, I don't discount that. But yes, Pepco was informed very specifically, Commissioner O'Donnell, of our specific issues with it. And nobody wanted to submit a third draft to the parties. I think that would have been better, and these issues would have been clarified.
And I can add.
So actually, before you get started though, let me ask you a question. Do you want to deal with all four as a group? Do you want to deal with each one individually? I mean,
I could deal with each one individually.
okay, so what we will do is we'll sort of discuss each concern that AOBA has brought up. I'll let Pepco go first. I'll let any of the signatories to the agreement make any comments after that, and then I'll come back to Ms.
Thank you, Your
Francis. So,
And I did want to address Commissioner O'Donnell's questions.
Okay.
We did have, pretty robust conversations with AOBA. AOBA submitted 3 different sets of comments. The first set, AOBA sent 6 edits. We either accepted those edits either verbatim or accepted it in concept with some wording changes. The second set of comments, or the second interaction with AOBA, is that we got on a phone call. So we had a phone call with them to talk through what their concerns were. Coming out of that phone call, we made an additional 2 comments and updates to the settlement. These last 4, we're at like the 6 weeks past the time period from the pre-hearing conference, and we really did want to get the settlement filed to give some clarity and certainty to the parties and the procedure and the proceeding going forward. So we looked at those 4 comments that Ms. Francis went over, and the determination we made is that we really need to, at this stage, after this 3rd round and coming down to really wanting to get this filed, we want to limit it to just critical errors, blatant mistakes. And if there's something that doesn't rise to that level, we were like, let's just get this filed. The types of items that Ms. Francis is talking about are more kind of clarifying comments and edits, and circulating another draft. And at that point, I had gotten 2 sets of consent. So I'd sent out a first draft and gotten consents from most of all the parties. The second draft had gotten consents already, and so this would have involved a 3rd draft going back out for additional consents. So that's the reason why I thought it kind of important to understand that history. I'm happy to talk about the first item
sure.
in Ms.
Why don't you go ahead, sir?
Ms. Francis' comments. She refers to the RDM rider, which is attached to the settlement as Exhibit C. Page 1 of 11, there's a paragraph under those 2 numbered paragraphs. What we were trying to do there was basically say, for that 3-month deferral period, we are going to hold the level of BSA revenue the same as the prior rate year. So that's why we refer to it as a full year. The point we were trying to convey is we're not going to make any changes to the BSA revenue targets. That's what we were trying to convey. What AOBA is asking for is to change that period down to 3 months. And Ms. Francis mentioned in her comments, it's not clear, it says, she asked the question, will you be adjusting for 12 months worth of data or not? Well, we don't do that today. So what we would do is our BSA tariff, as filed and approved by the commission, would still be in effect. And another procedural remedy that is available to AOBA is we're going to be filing a compliance filing on July 17th when we actually do the true-up. That's going to be an opportunity for them to examine it. If there's any calculations that they feel are inaccurate, they absolutely will have that opportunity to review it and file something with the commission to raise their concerns. So that was one of the reasons we looked at it and said, hey, do we need to send out another draft for this, knowing that there are a couple of safeguards that are out there?
So, staff, you have an opinion about this?
Yes, thank you, Mr. Chair. In general, I would say that we do not object to any of the changes that Ms. Francis is proposing, that AOB is proposing at this point. We also do not think they were necessary, which is why we were comfortable signing the settlement as it is and seeing it filed. I would note, with respect to what Mrs. Curry said about time concerns, this already was an extended process, and as she mentioned, the negotiations did go back and forth quite a bit, and AOBA did have a lot of input. At one point, AOBA asked staff to take a second look at some things, and we did that to reassure ourselves that everything was as we thought it was, and we're satisfied when we did so. So as I said, at this point, we don't object to the changes, but neither do we think they're necessary.
Mr. Auslander.
Thank you, Your Honor. I think OPC agrees with staff, and we take the same position that we don't object to these being a part of the approved agreement, but we signed the agreement also in the interest of time. I was aware of some of the changes that AOBA was proposing over the 6-week period. I guess I was not CC'd on every conversation, but we have reviewed their letter, and I think that we agree with staff's assessment that the agreement as filed appropriately addresses these issues, and we don't think that they're absolutely necessary.
And any of the other signatories feel strongly one way or the other. So, okay, take it.
May I make one other comment?
Well, actually, let me.
Okay, I'm sorry.
So, I want to give you a chance to respond, but in particular, I'd like you to respond to the point raised by Pepco that you'll have an opportunity in the TARE filing to sort of raise this concern. So, go ahead.
Yes, we will, but, and that is why, at the end of our comments, we do say, we requested that the commission either make edits to the provision of the stipulation relating to the RDM tariff now, or make those provisions subject to review as part of this proceeding. And I think that's what you're talking about, and I think that's what Pepco was discussing. We think it's really important that a tariff needs to be clear. And as Ms. Curry from Pepco explained, the way she explained it of how they were going to do the calculation, I understand that. That was one reading I had into it, but there were other readings. And I think if AOBA is able to read other things into those words, that customers will be confused. And one other point. We filed these initial comments, or we sent these initial comments to Pepco on July 19th. Unfortunately, I was out of the country, and I sent them at 2:20 a.m., so I can't tell you what time Pepco received them, but a full 2 days before this was filed. To take one extra day to make things that are not incorrect clear, I think was important. And let me just stress one other thing. AOBA, as far as we know, were the only party that asked for the Excel spreadsheets for the rates and how the rate calculations were done. And as far as AOBA is aware, it is only AOBA and staff that went through those calculations to verify those rates. It was a complex filing. There were over 35 different tabs. It did take us time to go through those rates to verify those calculations. I do not know to what extent any other party did what AOBA had done. And yes, we were on top of this for every step of the way because we believe this tariff is important and we believe we get it right. Yes, we did submit 3 sets of edits to Pepco. This was the final one. We felt it was done in enough time after we had spent, or Mr. Oliver clearly had spent, the time reviewing the rates as well as, and looking at the spreadsheets to say that we could go forward, that that wasn't one of the issues. And we urge the commission to make the change to the tariff now, since we have OPC and staff saying they are not incorrect, and Pepco did not say they were incorrect, or at the very least recognize that those provisions are subject to review as part of this proceeding.
So let me turn to the commissioners. Do they have any questions on this one? So.
Well, I'd actually like to hear from Pepco what their position would be if we were to accept the settlement, but provide that particular provision is subject to review just to the extent that it's determined at some later point in the rate case that some clarity would be useful.
That provision is already in the settlement. At the very end of paragraph 6, we added, and this was part of back and forth with AOBA, nothing in the settlement shall be construed of a waiver of the party's right to review and challenge the rates calculated in Pepco's compliance filing. So it's essentially in there.
Right. That it sounds to me like it's in there also. So what more would you need? So, Ms. Francis, is there something more that you would need?
Yes. Mr. Oliver just reinforced with me. That isn't going to happen until after the 3-month period. So that really isn't enough. It's saying I haven't waived any rights, but this is going to take effect after the end of the April 1st to June 30th deadline. So I don't really think that that's enough. I'm not waiving any rights. It says challenge the rates calculated in the compliance filing. It doesn't say challenge the wording of the tariff, which customers will see. And that's what my concern is. Customers will see that. We're not challenging the rates at this point, and that's what specifically that sentence says. Nothing shall be construed as a waiver of the party's rights to review and challenge the rates calculated in Pepco's compliance filing. That's different than what I'm saying now. I'm talking about the tariff and what customers will see.
Commissioner O'Donnell, any questions? Or actually, you? No. Okay. Commissioner O'Donnell, any questions? Okay. But let me just be clear on this. I mean, it strikes me that an important part of any rate case is review of the tariff filing. So, there's a determination made, after the case is litigated, is what the amounts are going to be and things like that. And I've seen over the years where changes have been made because the company sort of put language forward in a tariff and didn't get it right. And so we've had to make changes to it. So it strikes me that opportunity and that process, is in fact the check on making sure that this was done right.
That's a good point, Mr. Chairman, but let me say this, and this is why we were very careful when we worded it, saying make edits to the provisions of the stipulation relating to the RDM rider and the language of the rider, either now or subject to review as part of this proceeding. The RDM tariff was not part of the application. So we worded it this way to make sure if the Commission approved the stipulation with the rider attached, that AOBA would not be precluded from addressing the specific wording of the tariff and the specific wording of paragraph 6 at the conclusion of this case.
No.
And during this case.
I understand, but it strikes me that, when the company makes a rate filing, basically everything's on the table. It's not just, what they propose to change. I mean, any party can make suggestions on changing, rates, practices, whatever, and so I don't see how you're,
Because you're adopting something now.
Yeah, right.
Because you're adopting something now. And I didn't want to be in the position of you're adopting this stipulation, and the issue coming up, Mrs. Francis, you didn't address it at the beginning. You had your opportunity, and we approved it. So be clear, none of this was in the company's application.
Sure.
So I'm addressing this specific filing. I do believe that it's better to get a tariff right from the very beginning, but we did couch it in the alternative so that we would not be precluded from changing the terms of this stipulation as written and changing the terms of the RDM tariff at the end of the case and challenging it during the
Right.
hearing.
So,
I was just
Steve,
going to say, I mean, I think Ms. Francis' concern is that in approving the stipulation with the tariff attached, the commission is also approving the wording of the tariff, and that wouldn't somehow be subject to change at a later date. So that's,
And would Pepco, if we were to accept, we'd accept the settlement with the understanding that AOBA would be able to raise the tariff issue during the rate case, would Pepco have a problem with that?
Yes, we would. We need certainty on the wording of the tariff up front. And that's just part of the way the settlement works.
Well,
That's
but
part of the
you
compromise.
need it now before the rate case?
Yes, that's part of the compromise. So to the extent we're giving an additional 90 days, we need to understand that 90-day deferral period is not going to harm us financially. This tariff gives us that framework to enable us to be made somewhat whole. So we need that approval of the tariff now. So if they have if any parties have an issue with how we've calculated it in accordance with our tariff, they absolutely can challenge that. But we do need the tariff to be approved as part of the settlement.
Well,
Well-
I like, without sort of seeing the rest of a rate case, I'm a little uncomfortable about making a decision about a tariff if there is a party that would be impacted by the tariff and is having an issue and doesn't have a venue for raising concerns about the tariff. So, and I guess the question is, I mean, everybody's sort of reluctant to have the parties go back and make a change. Would you not accept the change that AOBA is proposing now to the language?
The first one that we were discussing with the 30 July, changing it from, just so I'm clear, changing it from revenue per customer targets in effect for the period April 1st through June 30th,
Yes.
we can make that change.
Okay.
But what it will involve is I will have to add it to the settlement, recirculate it to the parties, and have the parties re-sign.
Well, I think you've got most of the parties, or I think you've got the majority here. My sense is if we could get sort of closure on everything, it could be done today. I mean, you can just,
There are 5 parties that were signatories that are not here. They
Well-
were the ones who submitted
Well,
letters.
I understand, but I think, for want of a better term, you may have to pick your poison here and decide, do you want to wordsmith this document and accommodate these concerns that are being raised, or come to some understanding that gives AOBA a chance to sort of raise their concerns when they want? So, and I guess we're amenable to either process, though.
Well, I just want to make sure that, the record's clear. We do not want to have the tariff litigated as part of the rate case. That is the purpose of the settlement, is that the parties agree on these procedures to give us that certainty prior to us engaging or giving up what we feel are our statutory rights. This is part of the compromise. It's part of the settlement. So if we're giving something up, we need something in return. this is what we need in return to make this settlement happen and for us to give the 90 days. Now, if we're talking specifically about the item we just discussed and adding this language, we absolutely can do that. But what I want to make clear is that what we don't want to give up is the right to relitigate this tariff as part of
I understand. So, okay, so the first issue, you're okay with that language.
We
How
are
about-
okay
how
with
about-
that language.
How about the second provision?
Okay, so
The second provision, we have a similar comment that it's not something that is overly critical, it's not an error, it's not a mistake, and in fact, we think that AOBA's concerns are already addressed in the language as written. So going back to that paragraph.
Oh, okay, but I guess the question is, do you have an issue with adding that language?
We do not.
Okay, so
And-
how about
and
the third
the other,
provision?
well, actually, so staff and OPC,
We did not have any
you're
issues.
agnostic on,
So,
Correct.
Right.
third
We're okay with all
provision.
of the potential changes.
Okay, so
so,
the third provision, do you have a,
Have no,
okay.
no problem with
Okay,
that.
so then let's talk about the last provision.
The last provision, again, we don't feel that it is necessary. In AOBA's comments, they seem to be conflating kind of two concepts that are separate. The surcharge, the surcharge that will come out of the true-up on July, when we make our July 17th filing, is a separate process than the BSA, and what the AOBA's comments seem to link those two. And so that there was some, we don't quite understand what their concern is, but if those two concepts are separate, I would think that that is something that AOBA would not need in the agreement, because maybe they were making an assumption that the BSA is somehow tied into the surcharge. They are not.
Okay, but having that language and giving them clarity, is that going to be a problem for Pepco?
The language would change, it makes a fundamental change. It changes it from August 17th to September 1st. So that's a 2-week change. So that one, I guess, that's why I'd like to push back a little bit on AOBA, because if they want that change, if they want to change it from August 1st, from August 17th to September 1st, based on kind of an erroneous hypothesis that there's going to be some confusion with the BSA. What I'm saying is that confusion does not and should not exist. So I would say that that's not needed.
If I might, there was one issue with that last change that we would at least want the commission to be aware of, and that is if the commission were to change that effective date from August 17th to September 1st, that shortens the effective period of the recovery true-up surcharge, which means the charge would be slightly higher than it would otherwise be. Mr. Hopper can jump in and correct me if I'm saying this wrong or not explaining it correctly, but is my understanding on how that would work. So by shortening that recovery period, you increase the amount of the charge by a little bit.
Your Honor, may I have?
actually.
Oh, I'm
let me
sorry.
ask,
I'm sorry.
So I
take the bill, so.
yeah, I think OPC recognized that what staff is mentioning is the case, and we haven't done the math, so I don't know exactly what the impact would be, but we did know when we signed on to this agreement that that there would be an increase, that there would be a surcharge of the unrecovered deferred revenues for this extension period, and we were okay with that. And you know, I without seeing the actual rate impact for this extra 2-week period, I guess I couldn't necessarily commit, but I would imagine that it wouldn't overall change OPC's support of the agreement, even with AOBA's change.
Ms. Francis.
Your Honor, would it be okay if I have Mr. Bruce Oliver address Pepco's comments on this issue? Thank you.
Hi, my name's Bruce Oliver. I'm AOBA's technical consultant on this matter, and we've spent a good deal of time looking at the settlement, the tariff proposals, and the very complex and very extensive electronic spreadsheets that were provided us to support that. Part of the reason we didn't get our final comments in until the latter part of the middle of July was that it took time to get through all the documents. But first of all, there is nothing in AOBA's proposed edits that in any way challenges Pepco's ability to recover the revenue that they would be entitled to under the law. AOBA is very sensitive to that, and as we said in the comments, we are supportive of Pepco having a reasonable revenue deferral mechanism. So there's nothing in what we've proposed that is designed to in any way jeopardize Pepco's ability to recover the revenues it's entitled to. Secondly, the notion that the RDM and the BSA are separate mechanisms is undermined by the very fact that right on the first page of the RDM tariff, there is a paragraph that addresses its impacts on the BSA. They are closely related mechanisms, and one does affect the other and can affect the other. In the BSA tariff, it says how actual revenues are calculated. There's nothing in there that says that you extract RDM revenues when you're calculating actual revenues to after this goes into effect. So if you're in October of 2024 and you're applying the BSA, there's nothing that says that RDM revenues are not included in that calculation. That should be there, and it should be clear. I think,
Okay. Ms. Curry.
The surcharge is calculated separately from the BSA. And I'll ask Kasia to
Sure.
come up here to.
Well, actually,
President Mike.
why don't you take a seat next to her? That way Mr. Oliver can stay, because I suspect there may be some back and forth a little bit on this.
To give him some more details
Sure,
about
right.
how
Thank
the
you.
two are.
So
separate.
just state your name for the record. So.
Kasia Dana, Senior Manager, Retail Rates at PHI. DANA. So to maybe add a little bit more context here. So the RDM mechanism is impacting BSA rider only for the first 3 months of the mechanism. So for April 1st through June 30th. It is also a separate from BSA deferral mechanism that will be tracked separately from distribution revenue per the accounting rules. Effective July 1st, RDM and BSA are separate, distinct mechanisms. We would calculate the surcharge based on authorized revenue and collect that amount over the period that we stated in the proposal. The longer the period, the lower the rate for the customers. BSA process as designed and as has been operating for the number of years is not changing. Our monthly filings are performed as designed by the tariff, so there's no connection. Those filings are filed monthly, and all the parties have ability to challenge review and come back with questions.
Mr. Oliver, any response
Yes.
to that, or?
I have the BSA tariff, the currently applicable BSA rider tariff pages in front of me. And the BSA rider is very clear on the first page. It discusses the calculation of the BSA. And there's nothing in there that says that RDM rider revenues will not be included in actual revenues. If the company takes the position they have, then they need to modify the BSA language to make that clear, that the RDM will be wholly separate from any BSA calculations. That's not the way it's been in the past.
My response is that it is a granular detail that can be verified through the monthly compliance filings. We definitely agree that RDM is not included in revenue. It won't be included in the revenues. So distribution revenues filed as part of BSA effective July 1, 2024.
Actually, not to put you on the spot, but Mr. Hoppick, do you have some thought on this, or?
Apologies, was getting myself unmuted. David Hoppick for technical staff. As the Pepco technical witness stated, the BSA filings are made and are available. Staff receives the Excel filings and does review those filings. The RDM mechanism has not existed to date, so it would not have been part of the BSA, and we will be able to verify through those filings that it is not included in what is referred to as kind of the actual revenue, because what you're comparing in a BSA filing is the company's actual revenue to its target revenue, and its target revenue is decided as part of the kind of the commission's order in the case. That's part of the rate worksheets, and it's part of the compliance filing that commission staff and other parties review, and then you basically multiply the target revenue, which is a per customer amount, by the number of customers in the actual period to arrive at the target revenue, and that is compared to the actual revenue, and that then determines what the BSA difference is. The only other thing I would note is that regarding AOBA's filing, it refers to its concerns regarding timing on August 1st versus September 1st. It does not, to my knowledge, the filing itself refer to issues that would create a problem with the BSA filing itself for those forthcoming periods. I see Commissioner O'Donnell.
Yeah, Commissioner O'Donnell, go ahead.
Mr. Chairman, I'm going to suggest, not to take us off point here, but I feel like we're knitting around the edges forever here. If we approve this settlement, I'm prepared to support approval, and any specific items can be addressed by filings or clarifications through the proceedings. And we could be here all day talking about these little items at the 11th hour, and I just find it non-productive, and it's time to move on, in my opinion.
Commissioner Sussman, any question?
I guess, I guess, sort of listening to all of the conversation here, is AOBA still of the belief, in terms of the fourth issue, that your members will be affected by the no change in the language as it's
Change of the date.
or change of the date.
For the fourth issue?
Yes.
Yeah.
Well, I think Mr. Bruce Oliver addressed part of that by saying, reading from the BSA tariff, and there's nothing in the BSA tariff that says it will not be affected by the RDM. But I think maybe your question, you were talking about the dates.
Right.
Yes.
I'm going to ask Mr. Oliver to address that about the dates.
Well, I think Mr. Hoppick may have misstated. He said August 1 versus September.
No, I understand the August
Okay,
17th
August
versus
17th,
September
yeah,
1.
I think that proration does affect how it will impact our customers' bills for the month of October, or for the month of August, and will create considerable
But that's-
confusion right in the
But
time
but that's a billing issue. It doesn't affect how the true-up is determined.
No, It does not.
So I guess
it's a
I'm
billing
still-
issue
I'm-
that affects customers.
Okay, so I'm not understanding, I mean, it's not, your customers are not gonna be overcharged. Is that, I mean, because Pepco's gonna
No.
make a determination, it's just a date, right? Or
No.
am I missing something?
Because customers are not uniformly distributed across billing cycles, and because usage is not uniform across the period of a month, it's going to have different impacts on different customers depending upon how much of their usage is in which part of August.
Yeah, but that would happen, I mean, you're just gonna pick a date. I mean, it could be the 2nd, it could be the 14th, it could be the 1st. I mean, you're always gonna have, I mean, you do it over a 30-day period, but maybe, a company has an October 15th as the first day of their billing cycle, or I mean, you're always gonna have, I mean, I guess I'm not understanding, you're going to charge them based on their usage, whether it starts on the 1st or it starts on the 17th. Unless I'm not,
It gets much more complicated for individual customers to budget and understand how it's impacting their budgets when it's not a uniform application for all the properties, all the accounts that they are dealing with.
for that 2-week period.
For that
Or-
2-week period.
And then in the next,
It's an unnecessary complication. It's not a big adjustment, and it just makes it a lot cleaner if you start at the beginning of a month. I mean, nobody is greatly advantaged by starting in the middle of the month.
okay, so Pepco, what was August 17th a magical number, or was it just a compromise among parties?
It was kind of how the procedural schedule was laid out. So we get the commission order, we have to do an analysis before doing our true-up.
Okay.
We make a filing, then a month after that, and it just ended up being, because the earliest we could make our true-up filing is July 17th,
No,
and
okay.
30 days after that is August 17th.
Okay, so that,
Now, we
so,
prefer
so,
to stick by, I mean, the August 17th, we do want to stick by that date
right.
as we agreed to. in
No, I mean, I'm assuming, September 1st would have worked for you, but what you're trying to do is to manage a constrained schedule, and trying to start this as soon as you can.
That is
Okay, and that makes sense to me. I guess I'm just not, seeing why starting at August 17th as opposed to September 1st is going to have a huge impact on your members. I mean, maybe I'm just missing
Because
something.
the BSA is calculated on a monthly basis. And so if you do it on a monthly basis, you get the full customer usage within the month. And they can take a look at the past BSA surcharges and take a look at what's going forward when Pepco sends in, their monthly BSA adjustments, and it's done on a monthly basis. So that's why.
But it's gonna be a 2-week,
Right, but it's done in the middle of the month, and customers who,
for a single month.
In one of the highest consumption months. And that's also the time period where most of our members are doing their budget work for the next year. And you get results coming in that are askew, and it really confuses and complicates the budgeting process.
On that last one, it seems to me that if you're doing the budgeting for next year, if you start on September 1st, it's going to give you even less opportunity to incorporate that bill into your budget for next year.
You would know in advance that it would start September 1.
Well, and you can also alert your members. I mean, if you know what the schedule is, that's something that you can also let your members know that it's going to be a August 17th date as opposed to a September 1st date.
Mr. Chair, if I may, so may I make a comment at this
Go
point?
ahead, yeah.
So, Mr. Spivak raised the earlier point that the earlier we start this, the more it's spread out for the customer, which will reduce the amount of the rate. So, deferring it to September 1st, we don't know what the amount will be yet because it will be dependent on the final approved rates by the commission. But you're dividing by a bigger number when you start in August 17th versus September 1st.
So I guess the thought I have is your members are fairly sophisticated customers as opposed to Mr. Alexander's members. And so I guess my thought is that your members are probably better able to make the adjustments. And I understand that this could be a high consumption month, but, to sort of deal with these things as opposed to having the chance that we have a significantly higher surcharge because we've, changed this time period. So I guess I'm of the opinion of keeping the August 17th date. So.
I am
Your
as
Honor,
well.
It's not going to be a significantly higher surcharge in any scenario. And
No,
let's-
but it's going to fall, there's going to be a higher cost for residential customers who are, I'm a residential customer, I'm much less sophisticated than business owners. If you know in advance that this is what's going to happen, this is something that you can alert your members to get them prepared.
All right, so let me put it this way. So what I'm proposing is that we make the 3 language changes proposed by AOPA in the settlement agreement and keep the August 17th, 2024 date.
I agree.
Commissioner O'Donnell?
That's fine, Mr. Chairman. It seems like just about every case we have some dilatory tactic coming in at the 11th hour. And it gets old after a while, I gotta tell you. I wanted to state that.
All right.
But yes, I'll support that.
Okay, and so with that, we will accept the proposed settlement offered by Pepco and the signatories. So.
I will need to refile. I'll make those changes, and I'll get in touch with the parties today. If I don't file today, I'll file tomorrow.
Your Honor, I just want to take this opportunity to thank the commission for listening to these arguments. I appreciate it on behalf of AOPA.
Thank you, Commissioners.
Okay, now, before we go, we actually have one other item. There was a petition by ChargePoint to become a party. I think they're just an interested observer, but they want to be a party, and my understanding is that no one has any objection to that. So with that, we're going to grant their change to a party. And with that, we're done. Thank you.